I'm not a paperwork terrorist, but I can be. It's my second federal suit against Sacramento. I got a response from the court, an order to show cause. Quite excited because that means that they want me to pursue this suit against them. And I'm not asking them to change child support orders. I'm asking them to stop the withholding from violating federal law. So they take 60% of my check. They try to tell me where I can and can't work, that I need to go get something else. I'm paying for my son who hasn't lived with my ex in years. I caught them fabricating a proof of service. Why? So they can deny my motion to reconsider. Why? Laziness, just what they do, keeps them employed, or pure malicious behavior. Because a rational person would come to that conclusion, and that's what I said in this case. I mean, why else would somebody do that to another person? So my argument starts out with explaining the motion to reconsider and how it was denied for timeliness based on a proof of service according to the agency that never actually happened. So I, in attempts to fact find, started off with who served this and did it get lost in the mail. Well, come to find out, the person that supposedly served this hasn't worked for Sacramento Child Support since 2019. I did not receive substantial due process by the Department of Child Support in Sacramento County. Based on that, they should not be taking any more than federal law allows. Federal issue. I have a lot of federal issues with these people, but maximum allowable garnishment, the maximum part of aggregate disposable earnings of an individual for any work week which is subjected to garnishment may not exceed 25% or 30 times the federal minimum hourly wage prescribed by Section 206A1 of Title 29. Exceptions. The restrictions of subsection A do not apply in the case of any order for the support of any person issued by the court of competent jurisdiction or in accordance with an administrative procedure which is established by state law, which affords substantial due process and which is subject to judicial review. Petitioner argues although child support hearings may be subject to judicial review, substantial due process has never been afforded prior to actions against Ms. Peterson. Deference has prejudiced against her, and therefore 25% and or 30 times 7.25, which is the minimum wage, is $217.50, and is far less than the amount that is seized. Substantial due process cannot be claimed by defendants if they falsified a proof of service just to dismiss fraud allegations against custodial parent and continue admonishing Ms. Peterson for her American behavior. Has never received substantial due process in any family law hearing, including the most recent action of proof of service, in quotes, never occurring. With agency deference in tribunals, due process is never substantial in defense of non-criminal matters streamlined and deferred as a means to self-sustain an industry which claims to represent the needs of the voiceless liberty interests of impacted parents. Boom. Instead, developing the best interest terminology describing self as citizen and state, with services equaling survival of their own interests, to guarantee continuance of collection from those unable to survive off the income even prior to government intrusion. And a major question truly being, is the penumbra of liberty interest not equal to the liberty interest of self, preventing due process to the point of fabrication of service, sufficing as deferrable facts, never allotted the same rules of evidence because of lower court judicial notice of it. So to address the issue of fairness, to advocate against corruption within the system, if a party has
reason to believe that there is corruption within the court system, such as cases where an agency may be participating in fraudulent activity, a party should be allowed to petition a higher court for reconciliation, especially when the mere hardship imposed and expressed is met with hardness equal to admonishment for mere pleading its existence, let alone the actuality of the pure cause to forming a bias resistant of fairness to all. Federal law requires substantial due process, and I pray federal court will address this issue and offer the relief sought by plaintiff Peterson for damages by the Child Support Agency of Sacramento. To recommend a fraud investigation also, and how they did significant injury, extreme financial hardship, leaving her with the inability to acquire and sustain the resources needed to regain physical custody. Granting relief is just and proper under the circumstances. No contract to pay any agency or individual exists in this matter. This includes any implied contract for the mere advocacy of Ms. Peterson has performed for entertaining these administrative proceedings. All federal rules imply 25% and 50% garnishments. The hardship of the garnishment of 50% to 60 really, to traumatized, impacted parent trying to acclimate back into society gives absolutely zero incentive to continue being a good citizen. And a good, just, and productive citizen is the end goal and intent of legislation. Therefore, Ms. Peterson is asking the court for punitive damages. I bring this case against Sacramento County. So then I received an order to show cause based on it being a state issue, but I'm not asking the court to change the order. I'm asking the court to step in and stop violation of federal law by seizing more than the allowable amount. So I'm using Ex parte Young.
So I am using something called Ex parte Young. It helps you bring your case from state court to federal court. That's what I'm doing, and I'm not asking the court to change my child support order. I'm asking them to stop the violation of federal law by withholding 60%. Mind you, they won't even hear anything else in the state court. I know my situation is like a lot of people out there, and that's why I do what I do.